Next, Commissioners, we'll hear from another coalition. This coalition includes the Canada's National Firearm Association and the Canadian Coalition for Firearms Rights. They have opted to divide their time, so we'll be hearing from Robert Bracken, who's the Atlantic Regional Director of Canada's National Firearm Association, followed by Rod Giltaca, or I may have that, they'll correct me if I have that order wrong, the Executive Director of the Canadian Coalition for Firearms Rights. In advance of the proceedings today, I've been advised by this coalition that they will be submitting to the Commission 2 documents and asking that they be made exhibits, and I indicated I could assist them with the formalities of completing that procedure, so I'll do that now. The first document is a paper called Mass Homicide by Firearm in Canada, Effects of Legislation by Kaylin Langman, and it has been assigned a COM number of COM 0056196.
It's Exhibit 2144.
The next document has been assigned a COM number of COM 0056193. And it is a paper, and the title of the paper is a commentary on R. Blake Brown's The History of Gun Control in Canada, Report to the Mass Casualty Commission, an expert report prepared for the Joint Federal Provincial Commission into the April 2020 Nova Scotia Mass Casualty by Gary Mauser, PhD. I just wanted to clarify, just to avoid any confusion with regards to the title of the paper, as it appears on the first page and then in the body of the paper as well, that this report was prepared by this coalition and is being submitted. It was not a report that was prepared at the request of the Mass Casualty Commission. Madam Register, if you could assign an exhibit number, please.
2145.
Okay. And with those formalities completed, I'll look to who would like to speak first. I believe it's Rod Giltaca appearing virtually.
Good afternoon, Mr. Giltaca. Can you hear me?
Yes, I can. Good afternoon.
Commissioner McDonald here. Yes, whenever you're ready.
Okay. Well, good afternoon. Thanks for the opportunity to my part of this this submission is just to make a few salient points from our report. So as mentioned, the NFA and the CCFR were put together as a coalition. Our organizations are similar in some ways and dissimilar in others. So what we decided to do was to break our report into 2 sections, first being the CCFR's opinion of events and answers to the questions that the Commission had asked of us, and then the second part for the NFA. So I'm going to comment on my part of the report. So I would encourage everyone that has access to the report to read it. Certainly the CCFR portion is very, very short. It's only about 6 pages. It's very concise, and it's very logical. So the Commission, I guess in the beginning, asked us some questions, to address some questions, and if I were to paraphrase them, they would be: where and how did the perpetrator get his firearms? What were any regulatory failings in Canada's firearm controls regime? And do we have any suggestions on how to improve that regulation in order to mitigate or prevent events like this in the future? So I thought in my time, I would use my time to highlight a couple of important points, and really there's 2 important points. Number 1, all but one of the perpetrator's firearms were illegally obtained in the United States and, of course, illegally smuggled into Canada. The one firearm that he had in his possession, this is all based on the Firearm foundational document, The one domestically sourced firearm that he had was obtained through fraud, and I did not see any evidence presented in the foundational document that indicated that he used that firearm against anyone during his rampage. Next point, which is really important, is this individual was not licensed to own firearms in Canada. The perpetrator took one step towards the licensing process by taking the Canadian Firearm Safety Course. Anyone can, it's just a safety course, there's no vetting, anyone can take that course. But I can only suppose that when he was confronted with the application process, he decided that it would be far easier for him and more advantageous for any future activities that he just sidestep the entire regulatory regime all at once by not even participating in the licensing system. Now, what's important to understand, I think, or at least to consider, is that in our system, our enforcement and justice system operates on the idea of deterrence, you know, a moral or otherwise psychological deterrence. So if I were to behave badly in society, you know, be guilty of some criminal activity, there is a chance that I could be arrested. There's a chance that I could be charged with an offense. There's a chance that I could be convicted, or there's a chance that I could face some kind of punishment. If in regular criminal activity, most criminals do the math. They look at they do the numbers. They look at what are the chances that I'm going to get caught for this activity because I don't have a problem morally with this activity. And typically that's how you see criminals behave. In the situations like this, it's a complete abandon of the idea of deterrence. This individual did not care whatsoever what the consequences or the process there was. And that renders our infrastructure, billions upon billions of dollars and tens of thousands of people involved in that infrastructure, that enforcement and justice infrastructure, renders it irrelevant. And a person like this ends up in a new realm. It's a physical realm. The only way to stop someone like this is through a physical intervention. And in fact, we see this, well, virtually in every single event that fits this type of profile. And we saw it in this event where the perpetrator was eventually, once the police were able to catch up with him and identify him, he was neutralized and it was over. So that's something I think that is really important not to be lost in this endless discussion that we're having about this situation. It's really, really important that we realize this. So I guess all that to say that if you understand the reality of these types of events, and then you try to compare the regulatory system with them, firearm registration, magazine size capacity limits, licensing, possession offenses, not just firearm offenses, but any offense whatsoever, they're all rendered irrelevant in the face of someone who does not acknowledge that system, does not participate in it, sidesteps the whole thing. And to give you an example, we saw that in the Toronto van attack. An individual with a driver's license and $80 rented a van, and he was able to kill 11 people and injure, including critically injure 15 more in 10 minutes. So when someone steps outside of our system and decides it's meaningless, there's no intervention that is meaningful other than a physical intervention. And so I think that's something that people need to consider, or at least keep top of mind when we talk about regulatory reform. So in all practical matters, the most extreme regulatory reform would be a ban on all firearms. So understanding the fact pattern in this case in particular, there could have been a total ban on firearms for 50 years preceding this incident, and it wouldn't have changed this incident at all. Firearms came from outside the country, and you had a person who didn't participate in the system whatsoever. So it's just, as we move forward and talk about regulatory reforms, it's really important that we think about this. Now, as far as any question about how this individual was able to do so much damage in such a short time, I looked at it. I spent a lot of time thinking about this very carefully, and from a lot of different angles. And I think the unavoidable reality is that his ability to do so much damage came from the fact that he was impersonating a police officer. He was able to move around the community for an extended period of time evade police. In fact, the most damaging part of it probably was the trust that the public perceives in the uniform of a police officer. So metaphorically speaking, people would see a man with a gun in their hands and run towards that person instead of running away from them. So it's, you know, and I don't think it can be understated, the impact of that, because it even caused so much confusion that we had police officers opening fire on each other. And I'm not going to make any comment on that because it's outside my purview, only to say that that's the level of impact it had. So, you know, at the end of the day, our report really highlighted the fact that although we can talk about regulatory changes, we can talk about modifying behavior, but when someone, and this is why these types of situations are so unique, when someone steps outside the system entirely, there's really nothing to make a serious difference, certainly not an all-out ban on guns. And I'll close with one more remark. Because of the physical reality, not the supposed reality, not any type of spitballing about regulation, the physical reality, if there was a gun ban in Canada for the last 50 years, it actually would have put the public even more at risk. And I would just draw your attention to our report and just 2 paragraphs. I'm not going to read them, obviously. You can see the report if you're interested, but 2 paragraphs that involved the situation with Adam and Carol Fisher. So if you can imagine, there's a total gun ban in Canada. It actually would have made a negative difference maybe in that situation. I'm just supposing that we don't have all the evidence that we need to confirm that. In any case, as I said, thank you for the opportunity to make the submission and discuss our report. I'm going to pass the rest of my time over to Robert Bracken of the NFA.
Thank you, Mr. Giltaca. Commissioner Stanton has a question for you.
Hi, just when you say the commission asked you to answer those questions, do you mean in conversation with our staff when you became a participant in the proceedings?
I guess I'd say that, yeah, these were
Okay.
potential questions for our involvement.
Thanks. And then when you talk about your report, you're referring to the submissions that you have made that were sent in. Is that right? The submissions that you're referencing?
That's correct. Half of
Okay.
it was done for the CCFR and half from the NFA.
I see. Okay, yeah, because there were the other 2 reports, so I just wanted to make sure that I understood which document you were referring to. That's helpful. Thank you very much.
My pleasure.
Thank you again, Mr. Giltaca, for your presentation today. Mr. Bracken, whenever you're ready.
Okay. For brevity, I'm going to limit the scope of what I've covered for the simple reason that on our report to the Commission, the first part talks about 5 decades of failed gun control, but I'm not going to cover that. Azar Blake Brown has covered that, and he's done a good job of his historical perspective. But just in the intro, I'd like to add that of great concern to the NFA, we were concerned that this commission would be usurped by certain political and special interest groups who've attempted to portray this tragedy as both a gender-based issue and a reason for more gun control. We don't feel that way. We feel that at its core, this is about the failure of the incident command system with police and the criminal intent of Mr. Wortman. Sorry, the perpetrator. I'll try not to use his name. Anyway, that's just an intro. So what I wish to do, if you can follow in your guide, is start off on page 7. And one thing I wanted to quickly talk about were statistics. Canada's homicide rate actually peaked in 1974, about 3 years before the first big round of gun control, C-51. And one thing statisticians will say is you have to look at trends before any legislation is passed to see what was happening. And just on one side note, we were talking about non-firearms related incidents. I'm recalling the incident at the Bluebird Cafe and the Wagon Wheel bar in Montreal in 1972 when 3 intoxicated patrons were refused entrance. They returned with a canister of gasoline and lit the place on fire and killed 37 people using fuel and ignition as a weapon. And that's something that's often overlooked. Now, referring to a coal pump, I'm jumping around a bit here. I'm on page 7, so please bear with me. I'm trying to repeat what Brown said. But as far as dissonance or differing opinions, In the wake of École Polytechnique in 1989, the investigating coroner, Dr. Thérèse Serreux, wrote in her one-page conclusion in Chapter 3, the issue of firearms control has intentionally not been addressed. And she went on to state that the issues of police emergency response and pre-hospital care were matters worthy of their full attention. And at that time, Gamio Garbi, who was the perpetrator of that, well, it was understood that his father was an Algerian national who was a misogynist of the first order, which in no way excuses what he did, but at least gives some background. And years later, his mother would subsequently give an interview with the CBC and talk about that. And of course, since that time, of course, the events at École Polytechnique have been used to justify more control and exploit the deaths of 14 women. And I understand that the family of Hélène Kogan have given an interview with the CBC and talked about how much anger and sorrow this brings them as that open wound fails to heal. And I'm moving along then. I want to go to page 8, please, and mid-paragraph. In the wake of C-68 and debate in the Senate after the bill's passing, another senator who wasn't going along with this was Ann Cools, and she spoke eloquently against the bill and criticized the idea of a criminal penalty for not having a license simply to possess one's own property, which is what was brought in with that legislation. And she also took certain women's groups and others to task for attempting to treat gun ownership as a gender issue, as well as their frequently misrepresenting homicide stats and firearms use among domestic partners. The senator even quoted Blackstone, and her comments can be found online. I wish to jump ahead here, just for brevity. Excuse me. On page 10, I do reference Dr. John Lott and his website, crimeresearch.org, and this is a very good website for dealing with the mythology of the U.S., and I bring that into the conversation because in Canada, you almost can't have a conversation about firearms without dragging the U.S. into it, and then you see the arguments about the Second Amendment and some of the mythology we have in this country. One shocking stat I'll mention is that, and this was posted and updated in January 2016, that deaths from mass public shooting in Europe is essentially on par numerically when you compare those to the U.S., to Europe as a whole or individual states. In fact, there are some states that haven't had mass shootings. And murders in the U.S. are actually quite concentrated. 54% of counties in 2014 had 0 murders. 2% of counties have 51%, and that was from April 2017. Now, the perpetrator, as we know, used police impersonation, which is itself a crime. Now, we have seen the passage of the Police Identity Management Act, but really that's little more than political expediency under the guise of public safety and a solution for looking for really what's a non-existent problem, given what we know was going on that night. And I'll jump ahead to page 12. And the release of the 9/11 tapes in June of 2021, at the beginning of that situation, illustrate that the authorities and persons under attack by a said perpetrator who realized that the attacker was illegally uniformed and equipped. Okay, and of course we have also the ongoing allegations that the perpetrator was a confidential informant with the RCMP, which we still can't confirm. And on that note, I would like to move on, please, to Gary Mauser's commentary on Blake Brown's report. And I'll just briefly sum a few points. Excuse me. On page 3, the most important omission of Professor Brown's submission was his failure to address the effectiveness of firearms legislation. And down at the bottom of the page, Brown hasn't provided any evidence that any particular type of firearm, such as semi-automatic ones, pose any greater threat to public peace than any other. Moving to page 4. Rampage killers aren't limited to using firearms to murder victims. We've heard Mr. Giltaca reference that, where lately people tend to use SUVs and drive on sidewalks, which can be quite successful. And in the next paragraph, Brown notes there is no agreed definition of assault-style firearm. Indeed, that's more of a political term and encompassing cosmetics such as perhaps a pistol grip. But it mentions nothing about the fire control portion, which I think on a 1907 Winchester semi-automatic is the same. And this is how long semi-automatics have been in production. You know, going down to the bottom of the page, in page 4, If the government can confiscate property lawfully held and used by any group claimed to be suspect, then no one in Canada can consider their property safe from arbitrary seizure. And Brown mentions this when he talks about the 19th and 20th centuries, when certain ethnic groups were looked upon that way and had property seized. Page 5. Notably, Professor Brown didn't mention that the killer possessed his firearms illegally. Toward the bottom of page 5, more than 2 million Canadians hold a possession and acquisition license, now called the PAL. Page 6. According to StatsCan, their recent report to the House of Commons Standing Committee on Public Safety and National Security, PAL holders are accused of homicide about half as often as other adults. Excuse me. Now, that is no endorsement of licensing. I don't support the concept of licensing, but it does illustrate the government is continually attacking the wrong people. On page 7, second paragraph, although Professor Blake Brown makes few comments about whether firearms restrictions are effective, he does cite supportive journalists and public health activists such as Simon Chapman, whose research has been thoroughly discredited, and that's endnote 16. By ignoring studies by criminologists, medical doctors, and economists that employ more powerful research methods, Brown leaves a misleading implication that gun bans and arbitrary restrictions on firearms are an effective way to limit multiple victim homicides. Now, on that note, midway through the page, he talks about the testimony of Dr. Kaylin Langman. And on that note, I have Dr. Langman's Mass Homicide by Firearm in Canada, Effects of Legislation. I wish to have Dr. Langman subpoenaed so he can testify himself toward his work. He's unique in his approach to this, and to my knowledge, the only professional doing this sort of doing this sort of research in Canada. And he has published peer-reviewed research in the Journal of Interpersonal Violence. And now I've left time open for any questions. That's why I wanted to abbreviate it. And
Sorry. No questions, Mr. Bracken. Thank you.
Thank you for your consideration.
Commissioners, our final submission this afternoon will be from Suzan Fraser for the Coalition for Gun Control.
Commissioners, good afternoon. It's an honor to appear before you for the first time in this inquiry. We've been watching from afar. My name is Suzan Fraser. For those who don't know me, I'm here representing the Coalition for Gun Control. Before I begin my remarks, Commissioners, I'd like, if you could permit me, to express my condolences to the families and friends and communities and others, the victims of the horrific crimes that were committed April 18th and 19th of 2020. As a person who had a mass shooting down the street from where I live, where my children once played, I understand the corrosive nature of a mass shooting. We've lived through that. My sympathies are very much with Nova Scotians in what you experienced. The Coalition, just for those who don't know, the Coalition was founded in the wake of the 1989 École Polytechnique massacre in Montreal, where a legal gun owner killed 14 women and injured 10 women and 4 men. As many people will know, the December 6th anniversary of the massacre is now a National Day of Remembrance and action on violence against women. Surviving students and family members and victims of the Polytechnique massacre remain involved in the work of the Coalition, along with victims of other shootings. The Coalition is the leading voice of firearm control in Canada. It's also a globally recognized not-for-profit organization. The work of the coalition is supported by 200 organizations that represent diverse interests, including victims, women, healthcare professionals, lawyers, religious communities, municipal governments, and law enforcement. Many of these organizations have expertise in the prevention of violence and suicide and represent groups disproportionately affected by firearms violence and hate crimes. Turning to the reason that you gave me leave to speak to you today, Commissioners, so that the issues of the firearms evidence that you received this week, I'm going to just give you a little bit of a roadmap on what I intend to do. I intend to outline some process issues in terms of where we're at in being able to respond about the firearms issues. I intend to identify the gaps in context which we believe require further investigation and inquiry, and then propose some witnesses to be examined by the Commission, and just respond briefly to the remarks that you've heard from the NFA and CCFR representatives. In our view, in short, the material that you received this week on firearms and firearms access do not together yet provide you a sufficient basis upon which you can make findings of fact and ground recommendations based on complete evidence. So we're going to outline how we think you might round out that evidence. But first, as I mentioned, I'll speak to the two process issues that are of concern to the coalition. Like Ms. Huffman, on behalf of her client, we too just want to put a placeholder for evidence that continues to unfold. We do believe that the evidence of Lisa Banfield in terms of her interviews with the Commission could provide further light on some of the issues that you're dealing with on firearms access and border control. The second issue is just in terms of our involvement and our ability to assist you in this process. As you know, we were permitted the ability to consult on the rules of this process. In your rules, Rules 52 and Rule 67, provided a basis by which witnesses were to be dealt with and set out a process that you might receive panels of expert witnesses. All of that, when we reviewed those rules, we felt aligned with past inquiries and allowed participants to participate by questioning witnesses. On April the 23rd, Commissioners, we received a notice to participants that outlined the process for roundtables, and in that process, that significantly curtailed the ability of participants to be involved in the questioning of witnesses. We understood that instead of questioning of witnesses, that this will now be a facilitated discussion, and the notice of participants provides that the specific facts of the mass casualty will not be discussed, and that there'll be, and this is quoting from the notice, no active role for participants' counsel. In our respectful submission, if you're calling witnesses, experts, or otherwise to participate in a roundtable, those participants in the roundtable are providing you with become witnesses. You're going to rely on what they tell you, and your rules should apply to their testimony. And by that means, I mean the participants should be entitled to question them. And the reason that's important, Commissioners, is we all come having spent a great deal of time with our clients and learning from them about their expertise, and we want to be certain that when you have roundtables that we're able to use that expertise to help you test the evidence in order for you to have the best evidentiary foundation. We very much want the Commission to succeed.
Sorry, Ms. Fraser, I just want to clarify, I think. So if any of the people who are going to be part of a roundtable are people that you would also think would be valuable to be heard from as a witness, then absolutely that is something you would want to let us know. The roundtable process is intended to be a dialogue that we think will facilitate quite a bit of useful information if it's in a non-adversarial structure. So that's the intention with the roundtable, and certainly, as you know, participants have been invited to provide suggestions and questions and so on with respect to the roundtables themselves. But also some of the people who will be members of those roundtables will be heard from as independent witnesses, at which time you would be, of course, invited to as we've seen today, participate as counsel and question them and so on. It was just the intention to try to facilitate dialogue amongst people with particular expertise or knowledge in that format. So it's helpful, though, to hear that that doesn't, from your perspective, accord with how we were setting out our proceedings, and I'm very happy to take a look at how we're going about it, and I appreciate the input. So I just wanted to clarify, though, that some of the folks will be, of course, witnesses that will be part of that process, and then if there are others that are on the schedule as part of a roundtable that you strongly feel would be of benefit to hear from in a witness format or as a witness panel, certainly, as you know, our rules do provide for that. So.
Yes, if I may respond, Commissioner Stanton, just briefly. I do have some experience with the roundtable process through various inquiries that I've been involved with, the very first of which was the gouge inquiry. And the process that you describe of experts having a discussion around a roundtable facilitated by, in my experience, it was Commission Counsel, but here I understand it will be your research team, is very valuable. But in the gouge inquiry, for example, we were permitted to ask questions relevant to our interest in those proceedings. It didn't take very long. Like, there were usually just a couple of minutes because Commission Counsel did such a good job of eliciting that evidence, and I have no expectation that that wouldn't happen here. But it allows us to do our job from our client's perspective. And I think the second point that I would respond to is that even though there's a discussion and that is coming out through a roundtable, that still forms the basis of evidence. Those, whether you're receiving that, you're going to rely on it, and that's a form of evidence. They're witnesses in a proceeding, no matter what form they're taking part, in my respectful submission. And I don't understand how, if you're going to rely on the evidence, that they wouldn't be considered to be witnesses. If you don't have any other questions for me, I would turn to the issues about gaps in context, which is the second point of my submissions. So on the legislation, the Dr. Brown's report, Dr. Brown's report on the history of gun control and the report that you received from the Bridges-Tober pair, in our respectful submission, misses a couple of, several key issues that I think we can assist with providing you with more support for, or perhaps your commission counsel can obtain this information. Dr. Brown's report, for example, doesn't make reference to key Canadian judgments in the jurisprudence which add to the history of firearms access. For example, the Supreme Court of Canada's decision in Hasselwander found that Canadians do not have the right to bear arms, and that the licensing and possession of firearms is legitimately a highly regulated field. Also, for example, something that the Commission should have access to is the Supreme Court of Canada decision in the Reference Re Firearms Act of 2000, where the court addressed Parliament's constitutional authority to require holders of firearms to obtain and register their firearms. We think you should have before you, as part of your understanding of the legislation, information relating to the registry system that was in place when the RCMP, when complaints were received about the perpetrator's access to firearms. None of the material in Dr. Blake's report directly connects the issue of rural communities, firearms, and intimate partner violence. And it's the intersection of those issues that we think is essential for this commission to get the heart of. Further, none of the information that you've received speaks to the salutary effects of gun control legislation, in particular, setting community standards and impacting the culture of the community. On that issue of gun control legislation and impact, it's our submission that gun control legislation is very much a contribution, or contributes to community standards. If you think about how we lived our lives before COVID came to our shores, we had very little control of COVID coming to our shores. We had control when COVID arrived, but we're very much living in an environment where we're subject to what's happening around the world, like we are with guns. And our leaders were faced with choices about how to respond to that, to let everybody fend for themselves, to let a virus go through long-term care homes, through communities, through schools, and took steps to prevent the virus from spreading until we could employ further protections and understand more about it. And very much that helped us change our behavior. Community standards changed. We took turns protecting each other. I come from Toronto right now. I wear my mask because I know I have to get back on a plane. I want to be able to, if I have to self-isolate, that's something that I do for the benefit of the community, and that's what Nova Scotians would expect of me as a visitor. So legislation has a role in setting the community standards, and similarly, in gun control, legislation has a role in defining for people where the boundaries are. And it may be that there will always be somebody who's unvaccinated, who doesn't have a mask, who doesn't care where they go, they can spread it, but there will always be one-offs. But gun control does have a role in setting community standards. We think that the material that you have received is also missing gaps on, or has some gaps on intimate partner violence. We know from research that firearms are part of a cycle of fear in domestic violence where women and family members and even pets may be threatened. This is true in rural communities as well. Women are differentially affected by firearms. They are far more likely to be shot and killed by their intimate partner than by a stranger. They are far less likely to use firearms, and they are far more likely to support gun laws. Tellingly, a poll conducted by Canada, across Canada, revealed, as one might expect, that while the vast majority of Canadians supported the registration of firearms, about 2/3 of gun owners opposed it. And that's not surprising, but what is surprising, that almost the same percentage of people living with a gun owner supported the legislation. We think that the Commission can learn from the Public Legal Education and Information Service of New Brunswick. They conducted a survey in 2008 entitled Exploring the Links, Firearms, Family Violence, and Animal Abuse in Rural Communities. They concluded that while firearms were accepted as necessary in rural communities, fear of firearms misuse can become a community concern affecting family, neighbors, and service providers who are too afraid to call the police when they witness abuse for fear of retaliation. And that when women do disclose firearms misuse to a service provider, often no one follows up. Finally, we think that there is a reasonable body of evidence that suggests that high-income jurisdictions with stronger firearms controls, or with stronger controls on firearms, tend to have lower rates of rates of firearms injury and death. And we'll try to provide you with that literature in the process going forward. So we hope that through our participation in the roundtables and providing you with evidence, we can supplement some of these gaps. But I also think I need to address you on a third point of witnesses that we believe should be called to round out the facts. Like Ms. Hupman, we share the concerns that many people knew the perpetrator had weapons, family, friends, neighbors, clinic workers. Many were concerned about them and their inappropriate use. The perpetrator seemed to make no secret of his weapons, but he did secret them away. It sounds, based on what you've heard, that he enjoyed showing them off, pointing a gun at somebody's head once, showing his secret compartments, perhaps as intimidation. It is a key concern that few people reported. We think it's important for you to understand the barriers to reporting. So first of all, for those who knew that he did not possess a license, did they know that they could report, and to whom? Did they have confidence in law enforcement and their response? Was the lack of action to Brenda Forbes' complaint, did that have an impact on other members of the community? If you recall, commissioners, on April 11th, Richard Ellison testified here, his transcripts as part of these proceedings. And of course, he is the father of Corey Ellison, who was shot and killed. And when he testified as part of a witness panel on the Onslow Fire Hall, he said, you know, when you talk about safe communities, well, you've got to, people like the perpetrator showing me those firearms that he had, illegal, it might as well have been after Christmas, showing me a pair of skates. He had no fear of the law whatsoever and what he did, and he got away with it until they caught up with him, almost like a Sunday drive type of thing. It's just unbelievable. And if you remember, at the end of that panel, you asked him if he had anything else to add, or he was asked if he had anything else to add. And speaking of his son and Lisa McCauley lying dead in Portapique, he said it never should have happened in this country. You know, people talk about frontline or safe communities. Well, how can they be safe when there's no laws to prevent what happened in Portapique and in Wentworth and at the Onslow Belmont Fire Brigade? It never should have happened. That's the whole, that's the bottom line right there. Not in Canada, not with the gun laws they have, but you see, they only apply to law-abiding citizens, and you've got to get the criminals first, and there's your front line to keep your community safe and your children. And when he gave that evidence, I had many questions for him. What did he mean by that? Did he feel that the perpetrator was immune by the law from the law, and why did he think that? Did he feel police was ineffective? Was he aware of, for example, the perpetrator's friendship with Constable Wiley? Did that impede his thinking about law enforcement? I understand it's difficult in rural communities to report on known criminality, but that's a key part of what you have to do if you're going to make meaningful recommendations, is what people knew, and without blame, why did they not report? What did they think they could report? These questions that I've asked. And so there's a myriad of family members or neighbors that you could call or interview on these specific questions. We are making a specific request that you call Constable Wiley to testify about his relationship with the perpetrator. In his interview, which is part of connected to the firearms report, he said that his relationship with the perpetrator, he felt contributed to community safety in a community policing model. In his statement, he suggested this is something that he learned at Depot, that he was trained to connect with the community, and it appears to he have sustained this connection. But did this align with the RCMP's model of community policing to have one friendship in the community? Did he meet with others in the community? And did this friendly relationship with the perpetrator have an impact on the willingness of others in the community to report? So if Constable Wiley is regularly showing up at the perpetrator's house, do others in the neighborhood think that he somehow has a special relationship with the RCMP such that their complaint wouldn't be taken seriously? Hard to know, but it's important to hear this context. Similarly, we adopt the submissions of, on behalf of Ms. Hupman and on behalf of Ms. Merrigan, that Brenda Forbes' evidence is critical for you to hear from in terms of her experience. There's a clear dispute on what happened, and it's clear that she was one person who took steps to report the perpetrator. We also endorse hearing further information about border control. My friend, Mr. McClellan, on behalf of the number of families, drew your attention to the border control document, which was COM 28097, which is now an exhibit to this proceeding. I unfortunately didn't catch the number. And you also have a statement from Lisa Banfield in your proceedings, who said that the perpetrator had a Nexus card, and when he was stopped at the border, he complained to the border control people that he shouldn't be stopped, and that they apologized, and that it didn't seem to be a problem anymore. It didn't seem to be stopped. I think it's important for this commission to understand what the Canadian Border Services Agency knew, whether they actually had concerns about him being a high risk for smuggling and drugs, and we would ask that your council call someone from the agency so that they can explain their assessment of the risk the perpetrator posed. So those are my submissions on the issues of outstanding gaps in context, and also on potential witnesses. If I could just comment briefly on what you heard from the CCFR and the NFA. I don't want to comment on their submissions and their argument. I only want to say that they have tendered before you 2 documents which they purport to be expert witness reports for you to rely on. There was a process for us to propose experts for your council and your commission to retain and commission reports from. We don't have a process for others to tender their own expert reports, although we've been invited to tender policy statements, and we've been invited to tender literature that would support the commission's work, and there's a process for that, I understand it. But I want to just comment that if you're going to receive expert reports, that first of all, these haven't been tested, and it's unlikely that there is a process for that. At least there doesn't appear to be a process for that yet. And to be cautious of those reports that have not been the subject of cross-examination, and we'll likely have more to say on that at the end of the Phase 2 submissions. But I just wanted to highlight that because they were tendered without any statement of the experts' qualifications, any biases that the experts may have, or support for the work of the CCFR and the NFA and other proceedings. And so I just think it's important that I register that concern now while I have the opportunity. So subject to any questions that you may have, those are our submissions.
Thank you very much.
Thank you.
Thank you, Commissioner. That does conclude the submissions today from participants.
Thank you.
Thanks so much to participants for your submissions this afternoon. It's always helpful to hear from those of you we've been hearing from for a while, including those from Birchall McDougall, and from participants who have been following our work from afar and have not until today been speaking at proceedings. So it's good to have you here and here virtually, and to hear from you on the issues that are so engaging for you. And just to reiterate, the foundational documents are not the final word. They are our current understanding as of the date that they've been circulated. And as Ms. Hupman said, the door isn't closed on information. And as we go along, we are keen to continue to deepen our understanding and our knowledge of the factual foundation and the issues that arise from them and that are required of us to explore in our mandate. We, of course, want to thank Corps Sergeant Major Ellen McCambridge for being available here today, and for council to assist us with his evidence to help us better understand matters on the uniform matters. And thanks, of course, to members of the public and media for your continuing engagement. Tomorrow we'll hear from a number of witnesses. Constables Terry Brown and Dave Melanson will provide additional context around the events at the Onslow Fire Brigade Hall on April 19th, 2020. We'll also hear from Constable Ian Fahey surrounding what happened at Plains Road on April 19th and his initial observations of the perpetrator's replica RCMP cruiser, as well as Constable Dwayne Ivaney's attendance to Heather O'Brien on Plains Road and his encounter with Lisa Bamfield. A reminder, you can continue to review the information shared to date during proceedings on our website, which is where you'll find the foundational documents and source materials, the commissioned reports, the webcasts, the proceedings calendar, links to wellness supports, and much more information about the commission. So thanks so much, and we'll see you all again at 9:30 tomorrow morning.
Thank you. The proceedings are adjourned until May the 5th, 2022 at 9:30 a.m.